Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148. The name of the case is AZIM PREMJI Trustee Company Private Limited versus Principal Commissioner of Income Tax and others. This case has been reported in 448 ITR at page number 356 and the matter has been decided by Karnataka High Court. The date of the judgment is 21st April 2022. The facts of the case are like this. In this case, the notice under section 148 was issued to the assessee, which was 4 years back assessment, and when the reasons were given for this notice, in that reasons it was alleged that the assessee has not showed the fair market value and market value of the shares gifted during the original assessment. There is a proviso to section 147 which says that if the department wants to travel beyond 4 years and the assessment under section 143 subsection 3 has been completed, then the assessing officer has to show into the reasons that the income has escaped assessment and there was a failure on the part of the assessee to truly and fully disclose the material facts which were necessary for the assessment. Meaning thereby that in the notice it should be clearly established that which material facts the assessee has not disclosed during the original assessment and has to establish that how that non-disclosure has resulted into the non-assessment of that particular income. But in this particular case, the assessee has already showed the fair market value, the book value and the market value of the shares. The court also said that the shares which were the subject matter of the assessment were marketable shares. So the market value of the shares were well on the public platform. So it is not correct to say that the market value of the shares was not available. Apart from that, there was jurisdictional error in issuing the notice under section 148, where the proviso to section 147 applies, that the assessing officer has not disclosed and established in the reasons that how the non-disclosure of the market value of the shares has resulted in escapement of income. While in this case, the assessee has already shown the market value of the shares into the balance sheet of the company. So in this particular case, the appeal of the assessee was admitted and it was said that there was jurisdictional error in issuing the notice under section 148 and the decision was given in favor of the assessee. For this particular matter, a very recent judgment of the Supreme Court has come in the case of Assistant Commissioner of Income Tax versus CAT Limited, where the Supreme Court has dismissed the special leave petition of the department on the same subject, where the department has not disclosed in the reasons that which material facts were not disclosed by the assessee, and the High Court has given the relief to the assessee. So in that case, that is ACIT versus CAT Limited, the department was before the Supreme Court in the special leave petition. So now it has become a law of the land because the judgment of the Supreme Court has also come on the subject that if in the reasons it is not disclosed by the assessing officer that which material facts has not disclosed by the assessee and established in the reasons that how it results into the escapement of the income, then there will be jurisdictional error in issuing the notice under section 148 and you cannot reopen the assessment. Friends, this is a very important case because we have seen that in number of the cases that the assessment under section 143 subsection 3 is completed and the department issues the notice under section 148 in a very casual manner by sending the reasons which are not accurate, which are not in the true sense of proviso to section 147. They do not disclose the proper facts, that these facts were not disclosed by the assessee and how they resulted into the escapement of the income. So in these type of matters, those notices will not stand in the true sense of the law, and they have to be quashed. So now this matter has attained finality. At the end of this video, once again I am repeating the name of the case. The name of the case is AZIM PREMJI Trustee Company Private Limited versus Principal Commissioner of Income Tax and others, and this case has been decided on 21st April 2022, and the matter has been reported in 448 ITR at page number 356. Thank you, friends.